Good old Binger. Now, keep in mind, I know all about the appeal of Binger. He comes across with a lot of bluster. His rapid fire delivery, his self assurance, his constant claims that it's obvious that, and it's clearly that, it can snow the average person into thinking he really knows what he's doing. And so I get that some people might think, oh, yeah, man, he's really got Kyle over a barrel here. It turns out that we've seen Binger's crap before. He went after some poor truck driver over a concealed carry deal, and he got his ass kicked by the same judge. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dread Show.
So I want to thank one of my commenters, Adam Kolazinski, for sending me this. You know, that's one of the great things about working with pro Kyles. They kind of know that truth is on their side, and so they're willing to dig, and they're willing to dig, and they find things because they know that the truth is out there, and they're seeking it. The anti-Kyles, not so much. And guess what? It was Binger against Judge Schroeder. This is really going to be a lot of fun. And the title of this news article is Driving While Armed, Legal or Not. And it's by Bruce Villamete from the Milwaukee Journal-Sentinel. All right, let's read this. And by the way, this occurred in 2016. Kenosha, one of the first cases to test a lesser-known aspect of Wisconsin's 2011 concealed weapons law, came before a judge Monday. Gee, I wonder who that judge is. Oh yeah, it's Bruce Schroeder. The issue is whether you can drive with a loaded handgun within reach, even without having a concealed carry permit. All right, Guy Smith, a 52-year-old commercial truck driver from Merrill, believes, as does a gun rights organization, that you can. That's why he said he made no effort to hide his revolver when inspectors entered his big rig at a way station in Pleasant Prairie in June. Inspectors saw it on the floor of his cab via an overhead camera, then approached Smith and cited him for carrying a concealed weapon, a misdemeanor, and seized his gun. Smith's case was set for a jury trial Monday, but the prosecutor, I wonder who that would be, seemed ambushed by the defense claim that a different Wisconsin law seems to specifically allow Smith's actions. Gee, who is it that got ambushed by a similar case some months back? Yeah, it's Thomas Clare Binger. He has a habit of getting ambushed. It's called not being prepared. The statute on transport of weapons says, no person may place, possess, or transport a firearm, bow, or crossbow in or on a vehicle unless one of the following applies. 1, the firearm is unloaded or is a handgun. Gee, that sounds like it's pretty obvious, right? If I'm a prosecutor, I would look at this and say, well, as much as I would like to go after this truck driver because new truck drivers are so mean, unlike our BLM protesters who do nothing wrong, this truck driver is probably a right-winger. Oh, I got to get him. However, it does say here that the firearm is an exception to this. It looks like we are not going to be able to prosecute him. Most normal people would do that, but not Binger. He got ambushed. He didn't even know this was in the statutes. Dumbass. Okay, let's go ahead and read on. Assistant District Attorney Thomas Binger said that's a question of law that Smith's attorney should have brought up before trial. Should or was required to? That's the first question I would ask. The defense position would suggest anyone without a permit can drive around with a loaded weapon in the vehicle, Binger said. I decline to read the statute so broadly. I refuse to read it that way, I guess. I don't know. This is where Binger really shines. He said Wisconsin's concealed carry law, Act 35, would have no meaning if such was the case, right? And where have we heard that before? Oh, yeah. In a bail modification hearing, he did something similar. This is where the whole train comes off the rails here. And at this point, what he's going to say next would have me livid as a judge. I would be calling him and Cotton into my chambers and thrashing Binger for this. The defendant's interpretation of the exception set forth in 94863C would swallow the entire statute, which criminalizes possession of a firearm by a minor. What? Okay, so what's the strategy that Binger likes to employ? Let's go back. He basically likes to make this case that, well, Your Honor, if you interpret it that way, then the entire act makes no sense anymore. It negates the entire purpose of the act. Wrong. Let's go back. By the defendant's analysis, an adult would be free to give a firearm to a minor at any time. It could not be prosecuted? Good old Binger. How in the hell did this guy get a law degree? The defendant misquotes the statute to require that the minor violate the hunting statutes before a crime could occur. Yeah, Binger, we've already discussed that in the previous paragraph. And the defendant argues that since Kyle Rittenhouse was not hunting, he could not have violated the hunting statutes. This logic would immunize every minor from prosecution under Wisconsin Statute 94862A and every adult from prosecution under 94862B or 2C. So again, Binger makes this claim that, well, if you interpret the law this way, then the entire statute doesn't make any sense anymore. No, that's not true. Well, I don't understand where he's getting this. It defies logic. Yeah, well, it defies logic to suggest the legislature created a crime in section 94862A and then completely gutted it in the next subsection. Okay, let's examine this. I can't believe that he would actually even write this. All right. He is saying that the legislature created this section. Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. And he is claiming that this subsection 3C completely negates it. That's it. Let's read it. This section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun. Oh, wait a minute. This is specific to rifles or shotguns if the person is in violation of section 94128. What's 94128? Short-barreled shotguns and rifles. So right away we see a problem with this argument. It doesn't completely gut it, because if a person is being given a short-barreled rifle, they can still be prosecuted. And if you give a minor a short-barreled rifle, you can still be prosecuted. Why? Or if a person violates this subsection, then subsection 2A still applies. Unlike what he is saying, he's saying it was completely gutted. But it gets better. Or is not in compliance with both of these sections, 29304 and 29593. 29593, according to Mark Richards' argument at least, applies only to hunting. So it wouldn't gut 2A, because if you give a minor a rifle to go hunting, he's still on the hook. And 29304, let's take a look at that. 29304, restrictions on hunting and use of firearms by persons under 16. So let's take a look. Suppose you have a 14-year-old niece. Your 14-year-old niece comes over to the house and she wants to borrow one of your shotguns, for example. And you say, sure, take the gun down to walk around with it down to the park. Okay? Binger is claiming that I cannot be prosecuted for that because this exception that Anthony Cotton and Mark Richards outlined completely guts 2A, minor possession. So I cannot be prosecuted. It immunizes all minors, according to him. But does it? Well, let's take a look. Persons 14 to 16 years of age. Restrictions on hunting. Well, she's not going hunting, so we'll skip that. Restrictions on possession or control of a firearm. No person 14 years of age or older but under 16 may have in his or her possession or control any firearm unless he or she, 1, is accompanied by his or her parent or guardian. No, I told her to go take the rifle or shotgun and go have fun. Is enrolled in the course of instruction under the hunter education program. That's pretty damned unlikely. Is issued a certificate of accomplishment. No, she doesn't have one. Therefore, going back to 948.60, 3C, even if I gave her a regular shotgun, I would not be in compliance with 29.304. I would still be prosecuted. The whole Boolean thing here states that you cannot be in violation of this statute and you can't be out of compliance with both of these. It is silly, stupid to think that any minor can never be prosecuted under 948.62A because of 948.63C. I just gave you a very clear example of a situation where I would still be prosecuted. And so would she. So he's done this before. This is his favorite tactic, it appears. Judge, if you rule against me on this negates the entire law. Well, let's go back. Let's make sure we understand where we are. The defense position would suggest anyone without a permit can drive around with a loaded weapon in the vehicle. I decline to read the statute so broadly. He said Wisconsin's Concealed Carry Law, Act 35, would have no meaning. You're taking away the entire meaning of Act 35. But Judge Schroeder said no meaning in cars. Don't hand me that crap, Binger. You know fully well that it would not negate all of Act 35. It would only negate a portion of Act 35 having to deal with the transport of a concealed gun inside a car. So Bruce Schroeder is on to this dude. He caught him. The same tactic that Binger tried to pull back in the day when he wrote that whole minor possession brief. Smith's attorney, John Monroe, raised a second possible defense, that for a truck driver like Smith, his cab is at times his place of business and his residence. In either place, people who are legally entitled to possess a gun can have one for self-defense without a concealed carry permit according to state law. And my response to John Monroe is, oh, come on. Come on, Monroe. This is patently unfair. You've already got him on the other one. This is like scoring a touchdown and then spiking the ball. There has to be some sort of mercy rule here. You know, like when my Oklahoma Sooners played like Iowa State back in the 80s and they had the wishbone offense rolling and they were going to crush Iowa State, something terrible. And the coach of the Iowa State Cyclone said, look, can we just run the clock all the time? In other words, don't stop the clock when the player goes out of bounds or when they get a first down. That'll make the game shorter. The score won't get so far out of hand. And guess what? The NCAA went along with that. The mercy rule. There's a point at which you are kicking the ass of the other person, and the judge should step in and say, look, I mean, you've already got him on this one. Why are you bringing this thing up about the gun in a place of abode thing? It's a little bit unfair, but whatever the case. And of course, Binger didn't know anything about this either. You know, he was totally caught off guard by this, I would imagine. Oh, this is great. Binger argued that Smith could have easily gotten a permit, which would allow him to carry the gun in his truck. We still have a law against concealed carry without a permit, despite the efforts of gun rights advocates. In other words, he's picking up the mantle for the gun control crowd. But his argument here is so silly. He could have gotten one. Yeah, but that's not the issue here, Binger. The issue is whether he needed one. After the hearing, Smith said he didn't get a permit because he didn't need to. Yeah, it's all about what the law says. It doesn't matter if he could have gotten a permit easily. I'm just a trucker trying to stay alive, he said. Ooh, that burns Binger's ass. I want my gun back. Oh, you're not going to get it back, dude. And I don't want a record, and I'm not paying a fine. I didn't do anything wrong. This is a man of conviction. He absolutely fully believes that he's in the right. That doesn't make him in the right, but it also would give a person a little bit of pause about going after him. Maybe he is in the right. And it turns out he knew the law better than Binger did. Schroeder agreed with Monroe that Act 35 was part of a revolution in the law concerning guns. People have different views, he said. Some feel more protected with firearms, and it used to be an opposite view that prevailed among lawmakers. In other words, Schroeder is looking at the change in the legislation and understanding that it represents a change in attitudes towards guns and that we have to respect that. By the way, I've heard that name John Monroe somewhere before, and yes, I remember now. If you look at this article, Kyle Rittenhouse and the laws that will affect his case, he's quoted here. I read this article some time ago. I even did a video on a similar article from the Milwaukee Journal-Sentinel. It says here, Kyle Rittenhouse, a 17-year-old militia member, who has been arrested and is facing a homicide charge in the matter, was not old enough to legally carry the assault-style rifle he had, according to statutes, which say anyone under 18 who goes armed with any deadly weapon is guilty of a Class A misdemeanor. John Monroe, a lawyer who specializes in gun rights cases, believes an exception for rifles and shotguns intended to allow people aged 16 and 17 to hunt could apply. So yeah, I'd heard his name before, and I had to just do a little bit of digging, but he has made it in one of my videos in the past. He's out of Georgia. He clearly knows gun rights, and he clearly knows gun laws. All right. The judge agreed with Binger that it would have been more convenient for Monroe to raise his defenses in pretrial discussion or motions, but noted Monroe was not obligated to do so. Binger had indicated that if Schroeder was inclined to agree with Monroe and dismiss the case, the state would appeal. Oh, this is putting on a little bit of a bitch show. Well, if you rule against us, we'll appeal a misdemeanor. I mean, if I'm Mike Gravely, I'm going to go to Binger and say, oh, hell no, you're not going to appeal this. Look how much money this is going to cost. You got him on a misdemeanor. What are you going to nail him for? $500, $1,000? Are you crazy? You're going to tie up all of our time. This shit costs money. And you're going to appeal a misdemeanor over what? A truck driver, a good dude, a guy who's never been in trouble, who happened to have a gun on the floorboard of his cab, who never meant any harm, and you're going to appeal it. Jesus Christ. I mean, at what point are you obsessed? All right. At any rate, the whole idea of a threat to the judge, well, we'll appeal this, judge. Yeah, go on ahead. That should not influence any judge on any matter. Schroeder instead decided to adjourn the case a few months to allow both sides to brief the issues of the possibly conflicting statutes. In other words, hey, Binger, obviously you didn't do your homework. Maybe you guys need to set aside some time and go over the statutes and figure this out. Wisconsin Carry Incorporated, a gun rights group and a bunch of good dudes, thank God that there are groups out there like Wisconsin Carry, is providing Smith's defense. Monroe, his attorney, has won numerous other gun-related cases on behalf of the group. Is John Monroe working for Kyle now? I don't know. As the Wisconsin legislature attempts to restore freedoms in Wisconsin, like other states have already done, we cannot have rogue DAs and courts. Gee, rogue DA, does that sound like Binger? Oh, yeah. We cannot have rogue DAs and courts imposing their legacy approach to gun rights, which is no longer supported by statute, said Nick Clark, president of Wisconsin Carry. He said the group chose to help Smith because his case was clean, without any clouding issues of alcohol, traffic infractions, or a related crime scene, and would be a good way to clarify the legislature's intent to allow people to transport loaded handguns in their vehicles without a concealed carry license. Guy Smith, he's clean, no alcohol involved, no traffic infractions, doesn't have any criminal record. Oh, the kind of person just pisses off Binger. No, instead, we'll let the dude off that has like multiple rapes and all kinds of disorderly conduct charges. Those are the good guys in Binger's eyes. By the way, we have talked about being ambushed. Has there been another time where Binger has been ambushed? Oh, yeah. Remember this?
However, I do think that there is a basis with the course of conduct that we've seen here for the court to impose a consequence for the defendant's violation of the bond, which has been admitted by the defense, to increase his bond by $200,000. And until he does so, I think a warrant should be issued for his arrest. Now, I don't know how long it's going to take him to post that money, but I think that that's something that needs to happen here, because otherwise, there's no consequence.
Actually, there's a statute about warrants. There's a statute about warrants in these cases also.
Look at Binger. He's like, what? Statutes, huh? You mean like in the law?
969.08 subsection 5A. A court may issue a warrant for the
and Binger heads for the computer. What is he talking about? What statutes? He got ambushed.
defendant who has already been admitted to bond only if the district attorney complies with 969.08 subsection 5A, and that requires, number one, that the defendant was released on conditions, which is the case here. Number two, alleges the defendant violated a condition of release by committing a serious crime, which I haven't seen any allegation of that. And number three, that the district attorney provides a copy of the complaint charging the commission of the crime. So
basically the judge is saying, this wasn't play by you because of your sensibility or reasonableness. It's what the law says. By the way, Binger, you really don't need to be heading over there trying to read this stuff. This is a bail hearing about warrants. You shouldn't have to look this stuff up. When he's reading it to you, you should know this. How long have you had to prepare for this?
you're short on two conditions in terms of my issuing a warrant. Now, tell me if I'm reading that statute wrong.
No, you're not, Your Honor. I'm not alleging the defendant has a serious crime. I'm simply alleging he's violated the conditions of his bond by failing to update his address with the court.
But it says, let's get the exact wording.
I'm not a lawyer, so I can only guess here, but I think if you're making the judge head to the statutes all the time, that's probably not a good thing. If I'm a judge, not, so I can only guess at this, but I don't think I should have to head to that all the time. I think you should present to me what the statutes say, and you should be prepared. The fact that the judge knew about this particular law, and you have to look it up, is not good.
Yeah, it says, if the court, this is subsection B, subsection 1, 96908, subsection B, subsection 1, if the court determines that the state has complied with paragraph A, the court may issue a warrant. That's the limitation on the court's authority to issue a warrant, is if the district attorney has complied with paragraph A. And paragraph A is what I just read, and you're missing two of the three ingredients that would be required to empower me to issue a warrant. Unless I'm reading that wrong, and I don't think I am.
I understand, Your Honor. I am asking the court to increase the bond, however.
He wanted Kyle arrested. He didn't read the statutes. The judge had to read the statutes for him. And at the end, Binger says, well, okay, I guess we can't have him arrested. But can we go ahead and raise his bond? So this has happened to Binger before. Hey, Binger, if you're going to go into trial, you know what? You want the judge to actually do something for you? Read the statutes first. Understand the law. It's not difficult. Now you may be wondering, well, how did this all work out? I mean, did Binger carry the day for him? I mean, yeah, you've been kind of hard on old Binger here, Johnny Walker Dredd, but in the end, it comes down to what the judge wants. Suppose that Binger carried the day. He's got a lot of bluster. He's got a lot of confidence. He walks in, he talks a big game. Maybe he was able to carry through and save the day for the district attorney's office. How did this work out? It didn't. Prosecutors dismissed driving while armed case against trucker. He had to dismiss the charges. Oh my God. He got his ass kicked. This is really bad. I'll explain why here in a moment, but let's go ahead and read some of this. There he is. Hey, good going, guy. You are about 30 times smarter than the district attorney that you took on. So I'll skip down. And it says, "We are pleased the state came to its senses." Somebody did. I don't think it was Binger. I think that Gravely told him, "Hey, Thomas Clare Binger, I read the statutes too, and you have no case. And why in the hell didn't you read this before you went to court? Oh my God, this is bad. Okay, we are pleased the state came to its senses before wasting the taxpayers' money on a trial." Monroe said, "Even if the state did not afford us the courtesy of telling us it would dismiss the case before we prepared for a trial and traveled to Kenosha." And keep in mind, Monroe is out of Georgia. And so Thomas Clare Binger was so salty over this that he didn't even bother to tell the attorneys until the day of the trial about dismissing the charges. So he made this poor bastard fly up to Kenosha, go through all the trouble of preparing a defense. They walk in, and then Binger turns around and says, "Well, we're going to dismiss the charges." By the way, you might think, well, now, wait a minute now, Johnny Walker Dredd. Attorneys dismiss the charges all the time. Yeah, when new evidence comes up that may paint the defendant in a different light, they might dismiss the charges. Perhaps a material witness has died or something that was unavoidable. Dismissing the charges because you didn't read the statutes is stupid. There was no excuse for this. Thomas Clare Binger burned up a whole ton of money for no gain whatsoever. He was going after some truck driver with no record, trying to pin a damn charge on him, even when the law said that the truck driver was in the right, and he still pushed it, and he still pushed it, and he tried his hardest, but in the end, he didn't have a case. I have a feeling that it wasn't Thomas Clare Binger that decided to drop the charges. It was Gravely. Say what you want about Michael Gravely, but I think he saw a losing case here, and he just told Binger, drop it. This is ridiculous. Okay, there are some related news items here that are kind of interesting. While truckers are savagely attacked in southeast Wisconsin, Kenosha DA refuses to return the gun. Binger doesn't want to give the gun back. Several weeks ago, Wisconsin Carry Incorporated achieved the dismissal of charges against Guy Smith, a military veteran. Oh, the dude's a military veteran too. What else can you, I mean, did he turn out he was a minister as well? Worked in the Boy Scouts? Oh, never mind that. Hardworking, law-abiding truck driver from northern Wisconsin. In spite of the charges against him being dropped, the Kenosha ADA Thomas Binger has refused to return both emails and Guy Smith's firearm. Now that is salty. He's not returning the email correspondence, and he's keeping the gun. In the past couple of weeks, multiple truckers have been savagely beaten at southeastern Wisconsin rest stops. Okay, they have a couple of news items here. I'm not going to go ahead and click on them yet. I'll post the link to this in the description below. In the name of justice and trucker safety, the Kenosha ADA Thomas Binger should return Guy Smith's firearm immediately. Guy Smith, like many truck drivers in Wisconsin, deserve the right to be able to protect themselves from this savagery. We urge law-abiding gun owners of Wisconsin to email ADA Binger and tell him to honor the spirit of justice and the Constitution and return Guy Smith's gun. And there's his email address. It has always been legal to transport a firearm in a vehicle in Wisconsin if it was unloaded and in a case. In 2011, the Wisconsin legislature changed the vehicle transport statute, 167.31, to allow guns to be transported without being in a case, and handguns could even be loaded. There was no stipulation that this just applied to CCL holders. It is legal for anyone legally allowed to possess a gun to carry a loaded gun in their personal vehicle. Note, one must have a concealed carry license to be within school zones. Unfortunately, some DAs, I wonder who he's talking about, still want to persecute law-abiding citizens based on how the law used to be. So Binger didn't even keep updated on the law. He was working off the old law. And there's a link to the law. While Guy Smith should never have been charged with a concealed carry violation, WCI was pleased to see the state dismiss the charges without a trial. Unfortunately, as happens hundreds, perhaps thousands of times a year in Wisconsin, citizens who either have charges dropped, are acquitted of charges against them, are never even charged or accused of a crime. Well, okay, so that's a fragment sentence. I don't know how to go with that, so I'm just going to read on. In spite of their innocence, DAs and police departments refuse to return the firearms that were seized from law-abiding citizens. In many cases, citizens are given the runaround by police departments, told their guns can't be located, told it would take more money to get an attorney than the gun was worth, and other excuses. Many are not even told about the return of property petition that can be filed. The Milwaukee Police Department's gun desk is notorious for misleading citizens and giving them the runaround and forcing them to go to court to get a judge to order property returned. Wisconsin Carry now has had to use more of our resources to file a return of property petition, which is a lengthy process to seek a court order return which is a lengthy process to seek a court order to return Guy Smith's firearm. This is just theft. They just stole his gun. Insane. You know, the charges are dropped. Give him his gun back. You have no right to keep it. I've been pretty harsh on Binger, and I'm going to stay on it. This dude is a clown. He gets ambushed all the time by people bringing in statutes that he never bothered to read. He doesn't understand self-defense. I pointed that out in that other axe motion that he filed that was an absolute clown show of a document. If you want to see a very poorly developed legal brief, take a look at that. I'll link it in the description below. So, yeah, Binger's done this before, and guess who he went up against? Judge Schroeder. Schroeder remembers. Oh, yeah, I remember you. You're the dude that tried to get that poor trucker convicted over a firearm deal when it was clear that the law allowed him to have the gun. What the hell? You think that Schroeder's forgotten? Schroeder knows his tricks, and he's not falling for them. In that bail modification hearing, Binger tried everything, and Schroeder wouldn't fall for it. So it's going to be interesting to see how things play out. And again, thanks, Adam, for bringing that to my attention. I think it's really good information to know. Binger has tried these tricks before, and Judge Schroeder slapped him around. Like my video, subscribe to my channel.